y'all probably had better things to do today. I know there's a festival going on and gun show going on. We want to thank everybody for coming. It's very important that you be here, and I just want to say thank y'all for actually participating in the conversation. The main reason that we chose this particular venue is because about three weeks ago, a anti-Second Amendment group called Moms Demand Action had a meeting right next door, which actually had Chief of Lafayette Police speaking at it. Everybody's entitled to their opinion. As a veteran, I wore my nation's uniform to give them the right to have those opinions. We just felt it was very important to express the other side of the debate. So I want to thank y'all for coming, thank y'all for participating in the subject matter. Education on people that maybe might not know too much about firearms or about open carry, concealed carry in Louisiana, National Firearms Act, legalities of use of deadly force and things like that, and just general firearms questions. First of all, Acadiana Tactical Firearms would like to thank the following people and recognize them. Chris Artigo, who will be here any moment, who represents High Brass Firearms Training as well as Acadiana Gunworks. You may have heard him yesterday morning on KPEL. They do the Firearms Friday show. We also like to thank Glenn and his wife Jamie, Acadiana Gunworks, who could not be here. They had a previous engagement. And I also would like to thank Sergeant Jason Chambers, who is the officer in charge of the State Police Concealed Handgun Unit, who really wanted to be here. He was expressing a lot of angst that he couldn't be here, but unfortunately he had a conflicting duty at the opposite end of the state. But being this forum is going to look like it's going to be a success, he made me promise to put on another one where he could be here, and we're going to try to put on another one at a later time, kind of a ask the trooper kind of thing. So be on the lookout for that. By the way, this will also be the first and only time that we're going to hold these forums here at the library for obvious reasons. But if anyone knows of any meeting space that they'd like to donate, or if anybody can think of some sponsors that would like to participate, we'd be more than willing to hear about it. We'd like to thank Vic Gavan from Louisiana Carry, he's a big open carry advocate. Check him out on Facebook. He's going to have a nice little presentation for you a little bit later on. We'd like to thank Lafayette Parish Sheriff candidate, Attorney Mark Garber, Esquire, for showing up. Mr. Garber is not here in his candidate capacity. Mr. Garber is an attorney. He's a former prosecutor. He's also a former special agent with the Secret Service. So in reference to things that have to do with legalities, especially the letter of the law in Louisiana, as it relates to concealed carry, open carry, use of deadly force, National Firearms Act, things like that. If we need a legal opinion, we just so happen to have one right here in the room. We'd also like to thank Mr. Alvin Toniet of the Lafayette Public Library. Lafayette, it's a tool. It's no different than a hammer or a saw. It's a tool that is used to prevent and solve problems of an unfortunate nature which normally do with suit. Guns do three things. They function, they fail, and they rust. That's it. The term gun violence is a feeble vocabulary exercise used by groups and individuals seeking to demonize firearms and the people who use them. Violence is from the heart. I'm here to tell you that I have quite a few guns in my possession. And they either don't work or they must be the laziest guns in the world, because none of them have killed anyone. None of them have threatened anyone. You can take a loaded gun with one in the chamber, with the hammer pulled back, with the safety off, and put it on the ground. It will sit there for 1,000 years and not harm a single solitary soul until somebody picks it up. Now, why do we carry? I'm going to kind of set the tone for the rest of the presentation with an article that I wrote for National Carry Academy, which was posted online on their blog. Just kind of dispelling a lot of the most popular things that we go through. Mr. Artigo is going to talk to you in just a moment about gun etiquette. Mr. Cabana is going to talk a little while about open carry. Then I'm going to talk with you again a little bit about concealed carry. And Mr. Garber is going to talk to you about the laws of deadly force and things that have to do with the National Firearms Act and things of that nature, and whatever else he would like to expound on. He has a quite experienced background in firearms. So if you'll permit me. Why we carry? Putting the Second Amendment to the U.S. Constitution aside just for a moment, understand this. Every living creature has the right to live, and therefore the right to defend its own life. Gazelles defend against the lion with their antlers. The mongoose defends against the cobra with speed and sharp teeth and agility. Even the lowly poison dart frog has a lethal surprise for any animal intending to do it harm or have it as a meal. In nature, there are predators and there are prey. In nature, a predator is not good or evil. A lion's not an evil piece of work, is it? It's a freaking lion. It's a predator. That's what it does. It hunts prey. Primarily, though, to eat or survive. No one feels like the antelope is evil for stabbing the tiger with his horns. It doesn't want to be killed. It wants to live. Would you try to take away that animal's ability to defend its life? The answer is beyond contestation. The answer is no. Human predators, however, are a very different story. They're ambush predators, but however, not just to eat or survive. They are not looking for a fair fight, or challenging you for territory, or choosing a mate. What they are interested in is stealing or destroying your property, rape or assault, to injure you, to take your life or your loved ones, or all of the above. This is not social violence in the schoolyard or bar. They're looking to do whatever they want to do to you and then get away. No human being's fear trumps another human being's right to defend their own life or their loved ones. No one. What someone thinks is their right to feel safe does not translate into preventing a law-abiding citizen from carrying a firearm for self-protection. The Declaration of Independence states that we are endowed by our Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. It is protected by the Second Amendment. The right of the people to keep and bear arms shall not be infringed. The firearm is a tool, as I said before, no different than a hammer or saw, and used to solve and prevent problems of an unfortunate nature which no other tool is suited. It's an inanimate object with no will of its own. And as I said also, a gun will sit there on the ground for 1,000 years and not harm a single solitary soul until someone picks it up. It is neither good nor evil on its own. Should people have ample and proper training? Yes. But the law does not allow you to force them to do it. It's called personal responsibility. Should we keep criminals and the mentally unfit from having firearms? Yes. Current law already prohibits this, although we still need to work on the standards and technicalities of balancing medical and record privacy where it regards background checks and communication thereof. We love our police, but they cannot be everywhere, and the only one that you can always count on is you. But let me ask a question. Why is the Second Amendment the only one of the Bill of Rights that you have to pay to exercise? As I said before, zealots of either persuasion, pro or anti-gun, have the right to their beliefs. Our veterans paid in blood and will always continue to pay the price for that freedom. Pro-gun folks should reach out to those who rapidly and irrationally fear firearms and help them overcome it with understanding, knowledge, and education. Anti-gun folk should revere and respect the Constitution and the precious gift of freedom enough to at least sit down with highly trained, professionally qualified subject matter experts and ask questions and listen with an open mind. We pro-gun people are not crazy. We see what happens in our world and on the street every single day. As a Boy Scout, I was always taught to be prepared. Carrying a firearm is a lot like having a parachute. If you ever need it and you don't have it, you'll probably never need it again. Remember, the Second Amendment protects all the others, and without it, the rest of them don't matter. If you do carry, do so responsibly, be safe, and train like your life depends on it, because it does. And remember, you always need more practice. All right. Let's talk about open carry for a moment. Who in this room did not know that open carry is legal in Louisiana? Anybody? Okay. I'm going to introduce you to a very knowledgeable gentleman who's going to explain to you why that is not true. Open carry is legal. It most certainly is. Just like this lady is in the grocery store, just like I'm doing right now. With no further ado, I'd like to introduce to you to Mr. Vic, come on, Louisiana carry.
Good morning, everyone. So as you mentioned, open carry is legal in the state of Louisiana. Open carry is, like you said, is what I'm doing here today and what several of us here are doing. It's keeping your pistol in plain view at all times. It's always been legal in the state of Louisiana. So I've got a few case law, and I'm not going to bore you with too much of it, but I'm going to read just some excerpts of why open carry is legal in the state of Louisiana. So going back as far as 1850, there was a case called the State versus J.B. Chandler. I won't go into too many details, but the man was accused of murder. Essentially, he was carrying a weapon openly, and he was accused of carrying it concealed, and so he was actually acquitted of that charge. But just going to read this one excerpt here. It interfered with no man's right to carry arms, to use its words, in full open view. Oh, I'm sorry. The Act of March 1813 made it a misdemeanor to carry a concealed firearm. It interfered with no man's rights to carry arms in full open view, which places men upon an equality. This is the right guaranteed by the Constitution of the United States, and which is calculated to incite men to a manly and noble defense of themselves, if necessary, and of their country, without any tendency to secret advantage, or unmanly assassinations. So back in 1850, concealed carry was actually very uncommon. It was actually more common for people to carry their firearms in plain view. Back in those days, it was considered somewhat deceptive to carry a firearm concealed. Obviously, that's changed over the years, but that's kind of the first time it was mentioned in the case law in the state of Louisiana that the law that made concealed carry illegal did not impact open carry in any way. So then in 1975, a gentleman by the name of Fluker, James C. Fluker, was also charged for partially concealing a firearm, is what the intent of the charge was. So he obviously fought back, saying, no, I did not try to conceal my weapon in plain view. I see no laws that are against that. And so the judge agreed with him. And so, let me read this one section here. Clearly, the present version of the statute differs from its predecessors by requiring intentional concealment. Thus, the old formula, which required that the weapon be carried in full open view, is obsolete, making the offense of concealment a crime of specific intent. The legislator has abandoned the old rule that a partially hidden weapon is a concealed weapon in favor of a more realistic prescription that contemplates that a weapon, although not in full open view, is nonetheless not a concealed weapon if it is sufficiently exposed to reveal its identity. If the weapon is carried in a manner that reveals its identity, its carrier cannot be presumed to have intended to conceal it, and therefore is not in violation of the statute. In sum, the trial court erred in its application of the mechanistic standard that obtained under prior laws. The appropriate test to be applied in prosecutions for illegal carrying of weapons is whether, under the facts and circumstances of the case, as disclosed by the evidence, the manner in which the defendant carried the weapon evinced an intent to conceal its identity. Applying this interpretation of the statute to the facts of the case, we find no evidence of an intentional concealment of the weapon. The defendant wore the gun in a holster on his hip in open view. The gun was exposed except for the portion in the holster. There was no attempt to conceal its identity. It was fully admitted by the arresting officers that the weapon was sufficiently exposed to be fully recognizable as a pistol. So the important part of this is it defines what is the difference between concealed back in those days, when this gentleman got arrested, they considered the fact that you couldn't see the entire firearm, that it was concealed. So obviously, if you've got a weapon in